Welcome to the Dirty Verdict Podcast, where your hosts, trial lawyer Kyle Herbert and mediator Peter Taaffe, break down Texas legal news, lawsuits, and verdicts. And now, here's Kyle and Peter.
Ladies and gentlemen, welcome back to the Dirty Verdict with myself, Kyle Herbert, and my co-star, Peter Taaffe, Peter Taaffe Mediation. We are lucky to have an excellent lawyer with us, a guy I've known probably 15, 20 years, Mr. Brad Wyly of the personal injury law firm Wyly and Cook. Mr. Cook's here with us, but he is largely in a supervisory capacity to make sure we don't mess this up. But Brad recently went down to the courthouse last week and had a fantastic verdict for his clients. And so we've invited him in to give us the rundown on how things are going at the courthouse. Brad, before we dive in, tell me a little bit about you and your practice.
Sure. So I do primarily these days personal injury cases, mostly vehicular accidents, doing more commercial vehicle cases now than I was before. We also do first-party insurance cases as well. We're representing, homeowners in weather-related claims like the freeze. We have a number of those cases. And then my law partner does FLSA cases.
What is FLSA cases?
It's good. It's basically people that are not being paid correctly under the federal minimum wage laws and federal pay laws.
It sounds like something I could report to my boss, maybe get some cheddar going. Brad, where are you from originally?
I am from Galveston.
Are you born on the island?
I am BOI.
Wow. Incredible. And tell me where you went to law school.
I went to law school at University of Texas.
Smart kid. Always good to increase the collective IQ of the group with a guest. Brad, tell us about this case.
Sure. So the case we just wrapped up on Friday was a car wreck case here in Harris County. It happened in Spring, Texas. My client, a very good man, Julio de los Reyes, was driving a F-150 truck on the freeway heading to Home Depot, and the traffic came to a stop, and he was rear-ended.
How long ago did this happen?
This happened, believe it or not, back in 2016, July 2016.
Are the courts just that backed up, or was this case particularly complicated?
The courts, as I mentioned when we did our voir dire to pick the jury, the reason that this case took so long was because between the time of the wreck and when we finally got to trial, we had Hurricane Harvey, which, as you know, shut the criminal courthouse down and basically clogged everything up in the civil courthouse. And then we had the pandemic. And so, I don't know about you guys, but this was actually my first trial since the pandemic.
Wow. And did you do this? You did this trial in person, not Zoom or anything like that?
Yeah, thankfully. I know some lawyers have done them by Zoom. I couldn't imagine. And, it was nice being back in the courthouse.
I bet. Who tried the case with you?
So I tried it with our associate attorney, Warren Berlanga.
How'd Warren do?
I thought he did a good job.
Tell me about your client's injuries.
So Mr. de los Reyes, it's an interesting case. So Mr. de los Reyes suffered some typical injuries that you would expect in a car wreck, neck and back. He tensed up before he was hit, and so he had some wrist stuff. But most of all that healed relatively fast. But what made it an unusual case was he developed a drop foot.
All right, you got to tell me and Peter, what is drop foot?
So a drop foot is when when someone loses the strength in their foot and the ability to essentially raise their foot. And so what happens is it causes the foot to drag, and that can lead to causing people to trip.
Is that something that gets better over time, or if you got it, you're stuck?
It can, and that was sort of what we were hoping for early in the case. And but a lot of times drop foot can be permanent.
Any idea in Mr. de los Rios' case, had it resolved by the time of trial?
Yeah, so it had not, and the prognosis for him was that it probably was gonna be a lifetime thing. He had been wearing a brace to keep his foot sort of upright for a number of years, and he would have to replace that brace every year. But it looked like it was probably going to be permanent.
So tell me about all the shenanigans leading up before the trial? Was there any chance to get it settled? Why'd you guys have to try it? What's the score on that?
Yeah, so what's interesting about the case is, so as I mentioned, the main injury in the case was the drop foot. And I have been handling car wreck cases going back to 2006. I've handled thousands at this point, maybe even over 10,000. I've never had a client with a drop foot from a car wreck. First time I've ever dealt with it. So, one thing that complicated the case early on was State Farm was the insurance company for the individual that ran into Mr. De Los Reyes. And State Farm's position was, we know he had some neck and back stuff, but that all got better pretty quick. So we don't know about this drop foot thing. So we're not offering any money for that.
Because State Farm's never defended a case where there was drop foot.
I have to imagine, as big as State Farm is, they've probably seen it more than I
have. So what was the settlement position when you guys walked into the courthouse? Did they offered any money?
Yeah, so we had Stowerized State Farm years ago. Really, it was well into the litigation after Mr. De Los Reyes was deposed, probably 3.5 years after the wreck. We Stowerized.
And
State
just
Farm.
real quick,
Sure.
Stowerize means you give the insurance company an opportunity to pay, and if they don't, any damages awarded by the jury over the amount of the policy comes out of the insurance company's pocket. Is that fair?
Yes. Yeah, ideally. And in this case, the policy was $30,000.
Wow.
So after his deposition, I was confident we were going to settle the case. At that point, he had a very thorough workup, which I can talk about in a second. The drop foot, he was still dealing with it. It looked like it was going to be potentially permanent. With a $30,000 policy and clear liability, I thought we'd get the case settled. So I Stowerized, and the defense lawyer told me, I think we're going to be able to get this worked out. And, and then asked for an extension to have more time to be able to resolve the case.
I've gotten this letter before from State Farm.
Can I have an extra 30 days? Sure. And I thought we'd get this thing done back in 2019, and we never heard. I don't know. I can't remember if we never heard from them, but there were no offers. And so then leading up to trial, that was essentially the settlement position. We made so we got set again back at the end of 2021, thought we were going then. And me and Warren sort of talked about it, and we said, let's try to give them another opportunity to settle the case. So we made a demand. Of course, we weren't going to take the policy limits at that time, but we made a demand in the mid six-figure range, and they responded with tendering the limits. So they tendered the limits about a year ago. We rejected it. They never offered any more money, and that's where we were at the time trial started.
A lot of times when I deal with State Farm lawyers, they get increasingly confident the worse their case gets. And it sounds like they made some half-hearted attempt to settle the case, but then after that, they were like, you know what, guns blazing, let's do this thing?
Yeah, it was the old day late, dollar short type situation. And by the time they offered the limits, like I said, the ship had sailed.
Sure.
And so we go into trial, and it was, to say it was a heavily contested trial is probably an understatement. I mean, they threw a lot at us.
Give me some examples. Tell me what the big issues in contention were, what surprised you, what you thought the defense did well, what you thought they did poorly.
Sure. So the big issues, in my mind, I did not think liability was going to be a big issue.
Liability being whose fault really is it?
Whose fault it was. I mean, we're talking about a rear-end collision. And immediately I knew we were going to be in for a fight because they were so aggressive about liability. They said, that, one, they denied that their client ever took his eyes off the road. They said basically he was just following along, and then the traffic just came to an abrupt stop, and there was just nothing he could do. And then they tried to point the finger at Mr. De Los Reyes, saying he should have anticipated being run into. I was personally happy that they were fighting on those grounds because I always felt really confident in liability. But the big issue in the case was causation, because we're dealing with a very atypical injury for a car wreck, a drop foot, and the workup was, to say the least, the guy had an extensive workup.
Tell me, what do you mean by that?
So they were not, so let me back up. So as I mentioned, it was neck. He was treating afterwards for neck and back stuff. The drop foot was identified, I want to say maybe halfway through his therapy, that he was having the issue. And so then he was referred off to his family doctor, who then sent him to a neurosurgeon at Memorial Hermann, a guy named Dr. Escobar. And Dr. Escobar spent about 6 to 9 months trying to figure out what is causing the drop foot. We knew that it started after the car crash, but trying to determine where exactly in his body this was, this drop foot was being caused, because it was likely a nerve issue, was challenging. And Dr. Escobar talked about that in his deposition. He was deposed, and they ran a number of tests on Mr. De Los Reyes. I mean, MRIs, EMGs, multiple EMGs, multiple MRIs, and they finally narrowed down where they thought it was coming from, which, to get a little science here, we'll get a little science background if you're okay with that. Or if you want me to.
We went to law school because there was no science or math in the brochure.
Sure.
But I will suspend my prosaic understanding of the healing arts and let you go ahead.
Yeah, I'll try my best to explain it. So normally when you're dealing with a traumatic drop foot, meaning a drop foot that you think is caused by a car wreck, it's usually either coming from the lower back, so the lumbar spine, and a pinched nerve. Usually it's the sciatic nerve would be pinched at the lower back, the lumbar spine, and that's a frequent cause of these kind of things. Or it's coming from below the knee. The peroneal nerve is below the knee. And so that happens as well. People get compression injuries. That can lead to drop foot. So you see certain soccer players, if they're getting kicked in the shin, for example, a lot, they can develop a drop foot. Our guy's drop foot symptoms were actually isolated to his mid-thigh. So what they did when they did the second EMG, they found that his sciatic nerve, they called it a sciatic neuropathy, but it was essentially at his mid-thigh. So it was at not a common place. And so that was something that the defense really latched onto, when they were cross-examining Dr. Escobar.
So what was Dr. Escobar's ultimate opinion?
So initially, when Warren deposed him, and several years ago, and initially Dr. Escobar's opinion, when we first asked him, we went through all of it, and we said, "Doctor, what do you think is causing the drop foot?" And he said, "I don't know." That was his answer. Well, of course, that doesn't do us a lot of good, because as you know, as a lawyer, we need to be able to say more likely than not, based on a reasonable degree of medical probability, what is causing it. Warren did a good job of saying, "Well, doctor, this happened after the car wreck. All the other potential things that can cause a drop foot aren't here." And there are other things that the defense hammered on: diabetes, multiple sclerosis, just an obesity. There's
a bunch of stuff your client probably didn't have.
Yeah. But they brought it up, and there are certainly things that can cause a drop foot. But Warren was able to do a good job of saying, "Look, doctor, none of these things are happening here. The only thing we're dealing with is a car wreck and our client developing symptoms of drop foot very soon after." And so eventually he came around and he testified, more likely than not, it was the car wreck that caused it.
He begrudgingly tied the points together and gave you a causation argument to make.
And begrudgingly is generous.
Tell me what you mean.
Well, it definitely was pulling teeth, I would say.
Yeah.
It was hard to get him to say it. It wasn't the next, it was a line of questions, but he finally got there. And we felt like, okay, we've got that, and that's our burden, more likely than not.
And did Dr. Escobar appear at trial and back up his patient's testimony, or what?
He did not. We played his testimony in our case in chief. They played their cross-examination of him, and then it got sort of weird because the defense indicated in their case in chief they were going to call him back, and they sort of indicated that to us all week. And I can sort of tell you where it went if you want, or we can.
Yeah, go ahead.
Sure. So we get to Friday, which is they're supposed to close their evidence, and then we find out that Dr. Escobar is not testifying, even though they'd been telling us all week that he was. So,
they were trying to bluff you into it, and then they ended up not bringing him.
Well, he showed up at the courthouse, so they just didn't put him on the stand.
It was kind of like the two guys that are at the landing strip at the end of A Few Good Men. Mm-hmm. What are these guys going to testify about? The tower logs, and they don't have any idea what's going on.
Right.
Did you guys bring a doctor to come and tie all this up?
We did. We had to because, again, when our assumption was that Dr. Escobar was going to be put on the stand by the defense, we felt like, well, that's not going to be good for us. So we brought a treating doctor that we had referred our client to see to get a second opinion, a guy named Dr. Jeffrey Rubin, and we put him on the stand.
How'd Dr. Rubin do for you?
He was great.
And Dr. Rubin was another doctor who had examined your client?
He did. He was a treating doctor. He basically agreed with Dr. Escobar's testimony that this drop foot condition was caused by the car crash.
Before you jump to the end and tell us how you guys did, anything else stick out to you as particularly memorable about this trial?
Well, yeah, there are a number of things I think that came up and that sort of do come up in trial. We did the best we could to. They had another expert that they had designated, a Dr. Tassard, and we had deposed Dr. Tassard. And her opinion was essentially a drop foot is very hard to diagnose what's causing it. And I can't, based on what I've seen, I cannot tell you that the drop foot is being caused by the car crash. I don't. Her opinion was, I don't know. And so we moved to exclude her because that's just not a helpful opinion.
Right.
And there's a case, Christus v. Houston, out of the First Court of Appeals, that if you ever come across this issue, is very helpful, because it says that essentially where a doctor can only say I don't know, or an expert I don't know, it's not helpful, and it's a grounds to get their opinion excluded. And we did get her opinion excluded. However, they brought a chiropractor in their case in chief, a guy named Mark Davis, who you may have seen. He files a lot of controverting affidavits.
Okay.
And he's been doing it a long time, 40 plus years. And they were able to get in his testimony that he had reviewed the records and come to the same conclusion, essentially. So that opinion did come in, not from Tassard, but I don't think the jury gave it a whole lot of credibility, though.
How many days did your trial last?
So it lasted, the entire week. The Monday, we ended up, we picked the jury, but we busted the jury panel. We just did not have a good jury panel for us. We had a lot of people that did not like lawsuits, didn't like lawyers. I didn't like the panel.
Can't blame them.
Yeah, I didn't like the panel. So it ended up, we busted that one. Came back Tuesday, had a better panel, and we started, and then we finished Friday afternoon.
That's that's a pretty long trial for a rear end car wreck. And can give our audience some sense of how difficult the job can be for plaintiffs to prove their case.
It can be very difficult. I mean, as I pointed out the first day, you deal with a lot of bias going in against lawsuits. Frankly, I think, some of the advertising that's done around town and billboards and things like that don't help, or television. But so you go in somewhat at a disadvantage. You have to obviously address that, and you have to deal with that in voir dire. And all you're looking for is jurors that can be fair. And I always tell people when I pick a jury, I want you to be fair to our side, but I want you to be fair to their side as well. We want a fair jury for both sides. We don't want anybody, leaning one way or the other with an axe to grind one way or the other. So if you can get a fair jury, it's still challenging because in this case, it's one Harris County resident suing another Harris County resident. So this is not a case where I'm suing, say, Coca-Cola or Exxon or something like that. And so that also, I do think, plays into the difficulty because the jury is going to see themselves not just in the plaintiff's shoes, but also in the defendant's shoes. And I think you always have to be cognizant of that when you're trying these kind of cases. And, I've got some other thoughts on it, but to suffice it to say, it can be challenging. And lastly, this case was particularly challenging because we really didn't have any economic damages. I mean, There wasn't anything they could really do for Mr. De Los Reyes. There wasn't a future surgery that I could include as part of his medical that I could put on the blackboard and say, here's a medical bill for $200,000. You can pay this and help this guy.
Did you submit the past meds and ask the jury to pay those?
No, I didn't. They were under $30,000, and I thought if I submitted those, it was going to be an anchor. Because the damages in this case, it was never really about pain. The defense did a great job of showing that Mr. De Los Reyes had a lot of back pain in the months and years leading up to this wreck, neck and back pain. It was really a case about the drop foot. And so that's what we made it the case about. We just focused and honed in on that particular thing, and we didn't mess around that much with the other stuff.
So Friday morning, by now you've closed the evidence, which means the parties are done putting on their show. Warren's about to walk in and do his closing. How are you feeling? What did you tell the client? What were you preparing for?
I felt pretty good. I have confidence in Warren. It was actually his first close.
Oh, wow.
Yeah. So
we should get him up here. Why are we talking to you?
Yeah, I know. I'd like to. You probably should. But yeah, it was his first, and I felt good. I have a lot of confidence in Warren. I knew we had tried a good case. We had kept it pretty short on our side, and we were always cognizant of the jury's time, and we made sure to mention that in subtle ways. I do feel like the defense wasted some time on some of their examinations. I think they weren't efficient in some parts of their case. We made mistakes too, I get it. But going in, I felt good. I felt we had a good chance to get a good verdict.
So Warren goes in, does his close, other side gets their chance. How long was the jury out?
About 3 hours.
All right, hey, before we get into I think you're getting to the money.
Yeah.
Before you get into that, I got a couple blocking and tackling kind of questions.
Sure.
So just from looking at the online docket, which is public record, couple things jumped out at me. One, I saw that y'all filed motion for summary judgment on their affirmative defenses, no evidence, which frankly you don't see very often from plaintiffs' lawyers, but I think it was very effective. So walk us through kind of the thought process on that and how the judge's ruling affected the scope of evidence at trial.
Yeah, so it did help. Like a lot of these cases you get from State Farm or other insurance companies, they plead a lot of defenses, inferential rebuttals, things like that, that aren't applicable, like unavoidable accidents, sudden emergency, contributory negligence. The judge didn't give us all, but they gave us some of those, and it allowed us to narrow down the case. This was not a sudden emergency. A sudden emergency is when somebody else's negligence does not cause the crash. And, Mr. Escobar, the defendant here, was, I thought, pretty clearly negligent. So we just try to, if we can, to narrow the issues down to make it as streamlined and straightforward as possible for the jury.
Was there an attempt from the other side to get into some of those things that had been knocked out on summary judgment?
There was, and frankly, the other side, they got in some things that they probably shouldn't have. Violation, some motions in limine, things like that do come up in trial occasionally. You do the best you can to object. And I did a fair amount. I usually don't object that much. I did a lot of objecting in this case, and just because I don't like doing it. I don't want the jury to think I'm hiding information from them. But they did slip a few things in. Not so much on the sudden emergency, unavoidable accident, but I'll give you an example. Like, my client testified that this tow truck had pulled out and caused everybody to come to a sudden stop. So they put the defendant back up and they started asking him about the tow truck. Well, we're long past where you can designate a responsible third party to be put on the charge. Even though that's the case, in closing, the defense lawyer argued vigorously that the tow truck was responsible, even at one point drew a line on the charge, and we objected to part of her close, but again, they were throwing a lot of stuff at us, rapid fire kind of stuff, and the jury didn't buy it, but it's just something, as I do more of these, I just have to be more cognizant of.
Got it. And then just, I I saw that the defendants filed a motion to compel mediation. Y'all objected to that, and the judge went with you. So obviously the pleadings are out there. So just walk us through what happened with that.
Yeah, they wanted. I think it was after they had made the offer of policy limits. Was it before? Okay, Kelly's telling me it was before, but it was long after. I mean, this case had been pending for, the lawsuit had been pending for 3 or 4 years. The wreck happened 5 years before. The wreck had happened 5 years before. I mean, we were long past the point where we thought mediation would be productive. I think we did offer, because I almost always do this, where I have a Stowers situation, and I say, look, you didn't pay the limits. That ship has sailed. I'm never taking the limits. But if they would have been willing to negotiate above those limits at mediation starting, then we would have gone. But they never indicated that they were. And then it's just, well, what are we doing? It doesn't seem like mediation's productive, and so we asked the court not to force us to go.
Got it. And then last little detail question. So I saw that some of the lawyers involved were Allstate staff counsel, but then I think y'all were referencing State Farm was the insurer. So what was the insurance situation with the defendant?
So this is an interesting deal. So I didn't know until I noticed that another lawyer had come on. I guess I didn't look. I thought it was maybe their Stowers counsel for State Farm. But then as we got closer to trial, I looked her up and I saw that she was from Allstate, and I didn't make any sense to me because this guy had a $30,000 State Farm policy. So when we had our pretrial conference, I asked the lawyer, you're with Allstate, why are you here? And it turns out that there was another policy involved that we didn't know about. I don't believe was ever disclosed to us. The defendant was driving his girlfriend's car. So his girlfriend's car was State Farm. He had an Allstate policy, but both were $30,000. And Allstate never offered us any money either. So, it was kind of nice getting the verdict against State Farm and Allstate.
Yeah.
That's a unique double whammy.
Yeah.
You might be the only lawyer.
Discount double check or something?
You might be the only lawyer I know that's defeated State Farm and Allstate at the same time.
Thank you.
So, Peter, any more blocking and tackling questions?
So you were able to have Dr. Davis's affidavit struck, his counter affidavit on some billing issues, but he was still allowed to testify live on which issues? Was he narrowed in any way?
So one of the things that was challenging is we knew she had mentioned, the defense lawyer, that they were going to call Dr. Davis. We couldn't figure out why, because we had dropped our meds and we deposed him. Warren deposed him, and all he talked about was the chiropractic care. He said that our guy had 30 visits and it should have been 15 or some typical, like controverting affidavits stuff. Even though our guy was still hurt, they should have stopped his physical therapy after 12 treatments. I mean, it doesn't make a lot of sense, but he really didn't have any opinions outside of that. He might have taken issue with the MRI or something. Nothing about the drop foot. So they end up bringing him, and before they put him on the stand, we moved and we said, Judge, we have some concerns that his testimony is going to go beyond what he testified to in his depo, because his depo was limited to those issues. And the defense lawyer did a good job of persuading the judge that the designation was broader than that. And the judge, who did a great job in the case, she was fair to both sides. But this particular gentleman testified to a lot of things that went beyond what were in his report. And so we just had to deal with it on cross. I mean, it came in, he started talking about the drop foot and how, he's only seen 10 of them in his year's practice, and he didn't see anything to suggest that it was caused by the wreck. And so we crossed him, and Warren crossed him, and I thought did a very effective cross and kind of, saved us from, I think, what could have created a lot of doubt in the jury's mind.
How did Warren do that?
Well, he one of the things the doctor said was that he was not aware that a drop foot could be caused by a car wreck.
Okay.
The chiro. And of course, that was undisputed in the case. I mean, every doctor, MD, agreed that drop foots can be caused by car wrecks. So that was helpful. And then he pointed out that he had Googled something from PubMed to that effect. And so Warren pointed out that you did this vigorous, investigation, which included Googling, can a drop foot be caused by a car wreck? So, we were able to undermine his credibility quite a bit. I thought, he wasn't a bad witness, but I just think they should have never put him on for that. They sort of set him up to
Look a little foolish.
Yeah.
So it sounds to me like, this particular judge, for anyone who's going to be trying a case there, she is more of the view of err on the side of letting testimony in and let good lawyers, kind of like the Daubert quote from Daubert, best way to challenge an expert is through vigorous cross-examination.
Right. I think she did. With the exception of excluding Tassard, which her opinion was, again,
A non-opinion.
a non-opinion. I could have grabbed some guy off the street and he could have given me more information, she let most things in and she let us try our case. So, I was happy with it. Even the defense, we talked after, before the verdict came in, but they felt like they were treated fairly as well.
Good.
So let the cat out of the bag. Tell us, what did the jury come back with? How did they resolve this case for you?
Okay, so the jury...
And before you begin, just a reminder to the audience.
Yeah.
The most money at this point that was ever in existence on the table was $30,000. Fair?
Yes.
All right.
So the jury came back and they gave us a shade under $330,000, $328,000. It was all, like I said, it was all non-economic damages. And interestingly, they didn't give us. This didn't surprise me. They gave us very little for pain, and that's because the defense did a good job of showing that after 3 weeks of therapy, that our guy went to back to the chiropractor, complaining of basically that he had hurt his back because his pain level had gone down to like a 0. Okay, and then he comes back like a week later and says he hurt his back lifting an 80-pound sack because he was in construction. And I think that's why the jury gave us very little on pain. But they gave us about $100,000 on mental anguish, which, as you know, is pretty tough to recover.
Sure.
Especially when you're not dealing with pain. And they bought, the impairment. And they gave us $125,000 in the future for impairment and $110,000 in the past.
And did you bring experts on those topics, or did your guy just talk about what's going on in his life?
So with those topics, we put him on the stand, and he talked about it. And then we brought his daughter, who was a lovely person. She just graduated from University of Houston with a business degree. Had actually had a job interview lined up that day for Coca-Cola, to go interview at Coca-Cola. She was a great witness for us. We put her on the stand. She talked about her dad before and after the crash. She talked about how she could see that this had really affected him. He wasn't the same physical guy. And that's really what we put on as far as mental anguish and impairment, just the client and the daughter. And then, of course, we would ask the doctors about the impairment, and they all agreed that a drop foot is an impairment.
But no life care plan, no lost wages in the future, just straight up impairment, mental anguish, pain, and suffering.
Yeah, no life care plan because, again, it's one of those things where you wear a brace and you just sort of deal with it. You cope, and there wasn't any lost income. Our guy was out of work for a couple of weeks, but he's a builder, and he was able to keep his business going. And, in fact, the testimony was his business was thriving. So we had no hardly any economic damages in the future. The only thing we had was some past medical. It was all just non-economics.
Did you get a chance to chat with your jurors afterwards?
I did, and so there were 2 jurors that were against us that did not sign off on the verdict. One was juror number 1, and her husband was in construction, and he had a bad back. He had sciatic issues, and her whole position was the sciatic injury that Mr. De Los Reyes suffered that was causing the drop foot. My husband has that. He's in construction. He's chunking around 80-pound bags, and that's what Mr. De Los Reyes does. So I just can't get there. And there was another woman who she worked at a church, and she was against us the whole time, and she was just basically looking for reasons to not go in our favor. But everybody else I talked to, other jurors, and they all liked us. They liked our client. They thought he was telling the truth, and they went with us.
And your client, English speaker?
Yes. He had an accent, but yes, English speaker.
And that can be an obstacle.
Absolutely.
Yeah.
For him, it really wasn't. He was very relatable. I mean, he was born here, but I think he left and he lived most of his life in Mexico, and then he came back 8 years ago. So he had a very thick accent. But I mean, I didn't think that it was a big deal. He was good at communicating.
Did your jurors tell you anything in particular that they latched onto that made them lean your way as opposed to the defendants?
Unfortunately, I just didn't get to talk to him that much. Most of them, it was Friday afternoon,
Sure,
right before rush hour. Most of them bolted. So, I do plan on following up with them and seeing if I can get a couple of them on the phone because I would like to know.
Anything you and Warren would do differently?
Yeah, there's a couple things. I think, I would trial brief some issues, in particular with this chiropractor that they put on the stand, Mark Davis. Knowing that they were going to call him, I think we should have probably done a trial brief to alert that to the judge so she could have had more time to digest it, so to speak, as opposed to right before the man's here, putting him on the stand.
Sure.
I think aside from that, there's always, I guess, things you might do differently here or there. But I really think that we did a good job of trying a tight, efficient case and letting the jury know that we really valued their time and tried to get them, out of there as quick as possible.
How long did your presentation take?
It didn't take very long. Our direct, I think we wrapped up Thursday. So we started Tuesday picking the jury. We put our evidence on that afternoon. We were done in probably about 2.5 days. But that was also, a lot of that was cross-examination.
Sure.
And Mr. De Los Reyes, they cross-examined him for an hour and a half. So they took quite a bit of time. And Ruben was on the stand as well, our doctor, for a while.
Did you call the defendant driver as your first witness?
I did, and I crossed him, and like I said, I mean, I thought he was not unsympathetic. He had a nice suit on. I thought he presented really well. He has a good job. So I just stuck to the liability, knowing that you're supposed to leave enough room. You're not supposed to speed, obviously, and you're supposed to pay attention. And I got him off the stand probably within 10 minutes of cross-examination. Interestingly, in their case in chief, they put him back on the stand, and then they sort of opened him up because I thought they were just going to go do some background, tell the jury what you do for a living. But they put him back on the stand, and he started talking about the crash again and how he didn't know about this tow truck, and that just came into evidence. And so they tried to make that an issue through him, and I think that was a real mistake. And it also allowed me to get one of our best pieces. We had two really good pieces of evidence. One was he denied the entire time that he was not looking at the road. He said, I had my eyes on the road the whole time. Well, we had an EMS record where the EMS quoted him as saying, I was going 25 miles an hour and did not see the truck. So I got that in when they put him back up on cross. And then they did a real disservice to him because he was in his depot. He was pretty straightforward that it was his fault. My client did nothing wrong. But then they had him fill out an affidavit that basically retracted everything. That said, well, actually, I don't think I'm responsible, and I don't know if Mr. De Los Reyes did anything wrong.
Was that in the context of the response to your summary judgment?
Yep.
Yeah, so that brings up another, aside from the goal of obviously knocking out some of the affirmative defenses, did it also serve to flesh out some of their evidence?
Right, and again, that was probably one of my best points when I cross-examined him, and it made him look bad because it made me be able to point out to the jury, this guy he's taking responsibility, or he says he's taking responsibility, but here he is blaming it on the tow truck. And let me show you this affidavit where he totally said he wasn't responsible. So it allowed me to undermine his credibility, and I think it did help. And I think the fact that we filed that motion, it forced him to make that affidavit that we were then able to use to our advantage. I think they probably should have stipulated the liability, obviously, but they decided to double down, and I think it hurt them.
Did they make any effort to have two lawyers go at once, one to defend the Allstate policy, one to defend the State Farm policy?
No, they had the State Farm. There were two lawyers for State Farm that defended the case. The Allstate lawyer was there, but she basically was taking notes. She didn't really do anything.
Did you have any adjusters show up to watch close or anything like that? I always feel like that's a good sign for me.
Not that I'm aware of. I will say I did at one point when I had De Los Reyes on the phone, the head lawyer for Allstate showed up. And I've settled a case with him right before closing a couple years ago. Mm-hmm. So I know who he is. Nice guy. But he did show up. Their head of litigation. I don't know if State Farm did or not. They could have been there. I don't know. Did they? Okay. My law partner saying their adjuster showed up? Yeah. Okay. So I guess they did. I don't know.
Brad, that is a fantastic result. $300,000 plus on a $30,000 offer. And congratulations. Great job for your client.
Thank you.
That's really impressive. But sometimes you got to get 12 strangers down there to get you some justice.
Yeah, so what's next on the case? What are the next steps?
Well, we're just finishing up the judgment, and interestingly, this case is so old that the prejudgment interest alone, I think, is like $75,000. Yeah, so we've also collected some UIM money, which I think is good for our Stowers case because the UIM paid, so they valued it at least $60, right? But yeah, I mean, it's going to be a nice recovery for the client, and I don't know, they may appeal. We'll see. Jury's out on that.
Got it. So the next step is you submit a judgment to the judge to review and sign or take counter arguments from the other side.
Submit the judgment. My experience is usually you get a call saying, hey, will you take a little bit less or something, or if they want to appeal, they can do that. But, we feel good about our chances on appeal.
Good. Okay.
Excellent. Brad, thanks so much for being here. Next time, we're going to go straight to the source and bring your associate attorney, Warren, in. He'll give us the real dope on how to try a case. But, man, really appreciate your time. Congratulations on the fantastic verdict. And I'm sure we'll see you on down the road.
Thank you guys for having me.
Thank you.
All right.
Thank you all for joining us this week at the Dirty Verdict Podcast. For links to some of the stories discussed today, please visit our website, www.dirtyverdict.com. If you have obtained a recent verdict and want us to discuss it, please email details on the verdict to us. Also, please follow us wherever you get your podcasts.